Hi, this is Peggy Clary of Clary Law Offices, and I'm doing another one of our quick video chats that we try to cover a topic of interest for estate planning. And tonight's theme is really almost timely because I'm shooting the video after coming home from a pretty long day of work, and it's later in the evening. And to avoid the chaos and confusion of my home, I stepped out onto our front porch. And as you can see, way at the top up here is one of our pets, Mona, who we have already talked about pet trust in other videos, but certainly Mona's decided to tune in. But tonight's topic is really playing upon the concept of sometimes a lot of my clients tell me they feel in the dark about naming someone who can serve as their decision maker both during their life and post-death when they're unable to make their own decisions. And if you remember, Florida law has 3 areas which you can have decision makers involved in your life, and really 4 to be honest with you, but 3 happen when you are living, and the other decision making role happens when you have passed away. So during your life, you're going to have someone named a durable power of attorney that makes legal or financial decisions for you, healthcare decisions, and they're called a healthcare surrogate, and those decisions are minor medical and diagnostic. And then you'll have the living will when you're at an end stage of life and you're authorizing a surrogate to disconnect artificial means of support for you. And these 3 documents, they're an individual you select and can be multiple individuals that you feel will best carry out your wishes. And so maybe that's a family friend, maybe that's your husband, maybe that's one of your adult children, or it might even be a very fine medical professional you know who you trust their guidance and their decision-making ability. But on the advanced directives, your healthcare surrogate, your living will, and your power of attorney, Florida law has no requirements on who can serve as your nominated surrogate. Now, the last will and testament, the person who is in charge of administrating that document is what's called your personal representative. And the personal representative carries out your wishes and your directions when you have died, and those directions by you are upheld with highest level of protection under Florida law. So Florida does have, unlike the healthcare surrogate, the living will, and the durable power of attorney, 2 requirements that govern if a person is qualified to serve. And the first really pertains to the relationship to the person which you are naming. So they must be either 1, a resident of the state of Florida, if they're not related to you by blood or marriage. So I usually give the example of your college roommate who lives in Maine. They would be unable to serve. But your 5th cousin, twice removed, they live in Maine, they're qualified to serve under Florida law. Then the second area where qualifications come important is that certainly we have some requirements that make a lot of common sense in terms of you can't be convicted of a felony. You have to be able to serve, being physically and mentally able to undertake the task, and a few other minor requirements, but one of the attorneys at the firm can kind of review those with you. And those requirements, again, attach only to a person nominated to serve under your last will and testament as your personal representative. As you're thinking about who can serve, the number 1 message I like to give my clients is to give some thought as to the value and the decision-making ability that your named person you want to serve carries out. Are they someone that will follow your wishes? Are they someone who your value systems correspond with, or at least the person you name will honor and uphold? Because the person you're naming in all of these documents, whether you're living or you're dead, are individuals that are carrying out your wishes and your desires. So it's very important as you go forward, you name someone who's able to do that. So I hope my video, even though dark as it is, can help you see a little light in naming a person you value and trust to serve in your decision-making role when you can't. And most importantly, I hope you live a life that is marked with dignity, civility, and respect. And if one of our attorneys at Clary Law can reach out and assist you in this area, we'd be more than pleased to do that. 727-345-0041. And it looks like I've put our precious Mona to sleep. So hopefully that hasn't happened for you, and thanks for watching.